Hi, everybody. Thank you so much for joining us today. I'm Michelle Morris from Consolidated Planning Group. Today, we have got a fantastic webinar about the top 5 documents that you need in your life if you have an individual with any kind of disability. These are the documents, the legal documents that are going to help protect you and them in the future. So Christina Lesher is the attorney that's going to be speaking today. She's fantastic. Before I turn it over to Christina, I want to thank Lourdes Torres. Now, Lourdes is with, correct me if I get this wrong, Children's Disability Information Coalition. Children's Disabilities Information Coalition. Tell us a little bit, Lourdes, about what you do there and how you help families.
Sure. Thank you. Thank you, Michelle. Hello, everyone, and welcome. We are so glad you could join us today. My name is Lourdes Torres, as Michelle mentioned to you. I am the parent educator for the Children's Disabilities Information Coalition, or CDIC for short. We are truly grateful to Consolidated Planning Group and the Special Needs Attorney Christina Lesher for partnering with us and accept to present this important topic to our families. Thank you for being here. Before we begin, I'd like to take a moment to introduce you to CDIC for those who don't know what we do. CDIC is a nonprofit community parent resource center. It's a CPRC based in El Paso, Texas, funded by the U.S. Department of Education and the Texas Council for Developmental Disabilities. We serve parents, caregivers, youth, and young adults with disabilities from birth through the age of 26. Our mission is to empower families by improving outcomes for children with disabilities through free information, training, and support services. Some of the services, we meet with parents one-on-one to help them prepare for the ARD meetings. We have trainings, webinars, conferences, and many more events to help families of children with disabilities and with children with special healthcare needs to prepare a better future for them. And you can learn more about us at www.cdiclpaso.org or following us on Facebook and Instagram at CDIC El Paso. So once again, thank you for being here, everyone. We look forward to learning and growing together. And now the floor
Lourdes,
is yours.
what is the age range of people that you serve?
It's from birth to 26.
To 26 years old. Okay, great. Thank
That's
you
correct.
so much. And if you wouldn't mind, please put your information in the chat box so that people can have your email or those links, your Facebook pages, that kind of stuff. Thank you so
Sounds
much.
good. Thank you.
So again, I'm Michelle Morris with Consolidated Planning Group. We do these webinars 3, sometimes 4 or 5 times a week to try to help educate families who have any kind of loved one with any kind of disability. We are first and foremost a financial planning firm. We're located just outside of Houston, but we serve families all across the United States. Now, for today's webinar, we're mostly talking to parents who have an individual in their life that can be served by knowing what the 5 documents they need to have related to special needs planning, the 5 legal documents. This is being recorded, and we are going to send all these slides and a link to the recording out to you later on today by email. It is great. We love your questions and comments. Please put those in the chat box because I will be monitoring the chat box as I speak and as Christina speaks, and we'll be able to get to your questions. There's also some that have been sent in previously. We'll get to as many of those as we can as well. So again, we have over 30 years of experience with insurance and securities and investments, basically being financial advisors. But we don't just plan for the life of our clients. We also plan for their special needs loved one. And we plan financially until the end of that loved one's passing. We are members of the Special Needs Planning Academy. We are nationally certified as Social Security advisors, and we're members of the Special Needs Planning Academy. Did I say that one? Special Needs Planning Academy, Chartered Special Needs Consultant, and National Social Security Advisors. So families of all ages come to Consolidated Planning Group for things like lifetime protection plans, thinking about what happens to you or your spouse. What happens if the main breadwinner of your family passes away and that income, not only the income, but the help with caregiving is gone? How would your family survive? We can help protect you against things like that. Lifetime care, we talk a lot about the future cost of your child's care. Once you're gone, once you're gone and you're not here to just make it part of your budget, how are you going to help your child have enough money for their future? Transition planning. Of course, there's a lot of transition times in a person's life. When they turn 18, you have to think legally. When they graduate from high school, you want to think, what comes next. You don't want them to graduate to the couch. When they move on to their next residential situation, they're not going to live in their mom and dad's house forever, or are they? Is that what you want? Figuring out that transition. And then the transition that's going to happen when you as a parent cannot take care of your loved one anymore. What is that going to look like? We help families plan for all of those stages of life. We can help you understand ABLE accounts and special needs trusts, where the money needs to go and how it can flow for your loved one. And then again, as I mentioned, we're here to advocate for you and to educate you. Out of the entire United States, there are over 263,000 financial advisors, but fewer than 200 of those focus on special needs planning the way that we do at Consolidated Planning Group. And I would venture to guess that very, very few of those, 0.1% of all the financial advisors who focus on special needs planning, I think very few of those do the webinars and the educational aspect that we try to incorporate. So I'm very glad you're here with the experts in special needs planning. And it is so, so important that you find an expert because if you find a financial advisor or an attorney who is great, that's fantastic. But if they don't have the knowledge of all of these little nuances, you could end up paying double because you pay the first one to set things up and you pay the second one to go back in and fix everything. So you might as well start with a group of experts behind you. And that includes Consolidated Planning Group. And that includes Christina Lesher because she is an attorney that specifically understands these nuances. And I got her contact here for you, her contact information. I know there's some more in the chat box. And Christina, I'm going to turn it over to you now because this is why everyone's here, is to hear about these top 5 documents. So please.
Thank you. Thank you so much, Michelle. And it's so nice to meet Lourdes. I'm always learning about resources for my families and then resources for my own family. I've been practicing law for 22 years, but my interest in special needs planning really started to develop about 15, 16 years ago when my sister and I were both pregnant at the same time. I had a baby that was typical, and she had a baby that has special needs and is medically fragile. And so I've always practiced in the area of elder law, from taking care of my grandfather who had dementia That was the reason why I went to law school. I was a social worker prior to going to law school. And now I'm here helping families navigate these legal issues. And we're so glad to be able to work with CPG. I think you are one of my best resources. And I always tell my families, you know, at lunchtime, look at your YouTube channel because CPG has a YouTube on a video for every single topic. It's so expansive and great.
Thank
Okay,
you so much.
let's get ready. So let's think about these top 5 special needs documents. For those of you that are out in the audience, this title is really kind of a nod to David Letterman, and for those of you that are old enough to remember that show. So we're going to talk about a will or revocable trust, third-party supplemental needs trust, first-party supplemental needs trust, and documents that we need for incapacity. One of the things that Michelle and I always want to emphasize is beneficiary designation. So if there's one thing that you take home today, I want you to make sure that you have a list of all of your accounts and where those assets go at your death, because as we'll find out here in a little bit, putting a beneficiary for a child who's a minor or a child with a disability can really wreak havoc on that child's public benefits and can cause your family and your loved ones additional fees. So we want to make sure we get those exactly right. There's going to be some more information on that. Okay, next slide. So we're going to start with what lawyers called testamentary, or documents that say where the assets that you have go at your death. So every person that's over the age of 18 and has property will probably need either a will or a revocable trust. So one of the first things we have to figure out are, what is a probate asset? What is a non-probate asset? So a probate asset very typically will be a house. A non-probate asset will be any asset that has a beneficiary designation on it, payable on death, transfer on death. So a will is effective only at your death, and it can contain guardianship appointments for who will take care of your special needs kid at your death. And it can also contain a trust that will protect your loved ones from having too much money for Medicaid eligibility and other public benefits. So let's just take a quick pause because that was a lot that I just said. A couple of things. I didn't know what a trust was before I went to law school. My parents are school teachers, and so we didn't talk about trust. I want you to think of a trust like a cereal bowl, and we're going to put certain things in that bowl that are going to help prevent those assets being counted when determining financial eligibility. I think most parents out there or family members out there know that to qualify for Social Security or Medicaid, they will limit the amount of assets somebody can have. So if we set up these trusts correctly, we set up that cereal bowl correctly, we can leave assets to our children, our nieces, our nephews, our loved ones, and it won't be counted. And we also may be planning for children who do not have a special need that are minors. So I know as part of the planning CPG does is they may think their siblings, maybe one of them has a disability, but then the other two may need funding to go to college. And how are we going to be able to split up all that bucket of money? So I create the bucket, and then Michelle and her team, they create the money to put into that bucket. So
Christina, I think
yeah.
one spot of confusion that I often see from our clients is that they think that the special needs trust is an account or a place or a thing. It's
Oh,
really just
yeah,
the naming paperwork,
yeah,
right?
yeah,
It's not really even a tangible
yeah.
thing,
No,
right?
that's why it's really it's a paper doc, or it's a document that you sign that creates an entity. And so I have a coffee cup right here. It's
Mhm.
almost like this piece of paper creates the legal ability to hold something. So you're right, it's not a place, it's not a person. It is a legal document that provides instruction. Maybe that's the best way to explain it.
Thank you.
Okay, so your wills are only effective at death. Revocable trusts, that is back to the coffee cup explanation. So revocable trust, just like a coffee cup, and you can put things in it. We can entitle an asset in it during your lifetime, and then that revocable trust becomes a management. It's like a playbook to manage those assets. So for example, if I have a revocable trust, I'm the trustee, I'm the person in charge. If I become too sick and I name Michelle, then Michelle, you will be my successor trustee, and your job is to manage my assets in there. Then when I die, I've got two minor children and a special needs nephew. It's your responsibility to put the money into the trust for my two boys, and then the money into the supplemental needs trust for my nephew. So a trust is going to be effective during your lifetime and appoint somebody to manage those assets that are in the trust. You still have to have a will. We call it a pour over will, pour over, just like it's typed out there, meaning, hey, let's say I've got an asset that I didn't receive or inherited right before I died, and I didn't get a chance to go to the lawyer to do the paperwork to put it in the name of the trust. The will, or known as the pour over will, actually pours it into the name of the trust. You still have to go through probate, but it makes things a lot easier. So a couple of questions. A lot of people have asked me, gosh, isn't probate difficult in Texas? No, they've made it a lot better. But for my families that have special needs kids, including my own family, I like a revocable trust, because then Michelle and her team can say, oh, here's a life insurance policy. It pays directly to this trust that's already established, and we do not have to wait the 3 to 4, 5, 6 months to go through the probate process. Some assets are not placed into these revocable trusts for tax purposes, IRAs, life insurance. Who's going to be the trustee? That's a big question. Sometimes we will work with a corporate fiduciary, and we will definitely want to make sure that not only do we have a supplemental needs trust for those family members with a disability, but also for minors. So if you have named a minor on a life insurance, for example, through your office or your employer, a lot of people have this super cheap life insurance that you can get through your employer. And I don't think I'm mistaken when I think it's CPG's usual advice to say, go ahead and buy that. It's cheap, get it.
Yes, absolutely. If it's the least expensive life insurance you're ever going to be able to get. But the
Yes,
thing is that most people just automatically say, okay, if I die, it's all
right,
going to go to my spouse. And if he dies, it's going to be split 50-50 or split evenly between our children. But what if
right,
one of your children have a disability?
right.
Don't do that.
Or as a minor.
Or as a minor.
So
Yeah.
they'll say, you don't want to have a minor have life insurance. Number one, it's not a good idea. And number two, the life insurance company at your death is not going to write a check out to a 10 or a 12-year-old. You're going to have an expensive court process to get the money. Don't want to do that. Have a will or trust, and then carefully review how each life insurance or bank account that you have is set up so that you make sure the beneficiary designations are pointed in the right way. So for example, I have a life insurance policy for my nephew, who is directed to a supplemental needs trust for his benefit. If he fails to survive me, then it goes into the trusts that are established for my minor children. I have boys, and so they are not going to be able to touch their money until 30. We may increase that age, but we'll see. The frontal lobes are still being baked. So if you take nothing away, Michelle and I really want everybody to have a list of where your assets go, and you know where that asset is set up at your death. Okay.
That's right. And if we do a plan for you, if you ever do a plan with Consolidated Planning Group, that's one of the things that we check on all of your accounts as we're analyzing your financial picture. We do check the beneficiaries for you.
And so why do we need these supplemental needs trusts? Most Medicaid programs, Social Security programs, they're going to say you can only have an X amount of certain types of assets, and then you become financially ineligible. And by the way, there are 109 different Medicaid programs in the state of Texas, all with different rules. So that's why it's incredibly frustrating and confusing for families to navigate this process. But in general, Medicaid is going to, and Social Security. And by the way, Medicaid rules are based on Social Security rules. So Medicaid is going to follow those Social Security rules, and they're going to say, listen, if you want to apply for benefits, we're going to look at all the assets that are in the beneficiary's name, and if their assets have more than $2,000, what we call countable assets, then that's going to be a problem. So we allow for the funding or the placement of assets into a trust where it's not considered a countable asset. Now, one thing I just want to make clear is that for SSI, they will count or deem the parental income and assets until that child turns 18. There are Medicaid waiver programs such as CLAS, MDC, PHCS that waive, or they don't look at those, the parental income and assets. But most of our families are thinking, man, we just got to make it to age 18 and then we'll apply for Social Security. Then the family's definitely going to want to make sure that they leave the assets to that child that's applying for SSI, their money or their inheritance or their gift, in a supplemental needs trust, so we don't go over that countable asset cap. A lot of times the families will say, I don't want to set up a supplemental needs trust. I don't like trusts. I really trust my daughter. I'm going to give her the money and she's going to hold it for my son with a disability. Big problem. Number one, what if the daughter gets sued? What if she's in a car accident and her car insurance doesn't cover the other car that was in the accident? What if she's in a divorce? What if she has creditor issues? What if she begins to use that money? What we like about a trust is it provides structure and a succession plan for who will be in charge of that money for your child after maybe the initial trustees are unable to serve. So I'm the initial trustee for my nephew's trust. We've got a backup plan for 2 or 3 people to serve after me in case I can't. You can make all those arrangements. We hope that no one in our family becomes a bad actor, but sometimes things happen. So I don't advise people to leave money and just hope someone else is going to take care of it for their loved one. Okay. Third-party supplemental needs trust. What's so interesting is that the term supplemental needs trust, it's like it causes terror in the eyes of parents because they think, I don't want to leave assets in a vehicle that's going to have to pay the state back if my child dies. Well, if we do this correctly, there is no payback provision with third-party supplemental needs trust. So where the money comes from and how the money gets to the child is going to determine if we have to pay back the state or not. So if you send it directly to the third-party supplemental needs trust, you make that life insurance, that asset payable to the trustee, and those funds can go in that third-party trust, and they do not have to go back to pay the state of Texas or whatever state provides Medicaid. Let's say you accidentally name that life insurance policy at work to a child. That's going to have to go into what we call a first party trust, and that has the payback provision. So these third party trusts, they can be put into your will, they can be put in a revocable trust, they can be a separate document, they can be established by anybody. I could set up a supplemental needs trust for Michelle, or Michelle could set up a supplemental needs trust for me. The person who's in charge of making distributions or taking money out of the trust cannot be the adult or the child with a disability. It cannot be the beneficiary. We have to figure out who another third party person who can manage those assets if we're not to.
This would be a good question if you have a second, Christina.
Yeah, okay.
That one?
Yeah, let's see.
What if there's a policy already in place with the disabled person as the beneficiary, but the custodial parent doesn't have access to make any changes to that policy?
That sounds like it's a divorce case to me.
Mm-hmm.
I mean, what I would do, number one, is you hope that whoever has the ability to make the payout, you tell them they need to put it to a third party supplemental needs trust. If that is not possible, then I would go ahead and set up a first party supplemental needs trust so that if that person dies, that is the insured, and then you will have a receptacle for funding of the first party funds. A lot of other things come into play, Jennifer, for your question. For example, are they under guardianship? If they're under a guardianship, then the court's going to want to get involved. and you're gonna have to get court permission to set this up. The least painful would be to try to get that person who does have access to change the beneficiary, but we all know that doesn't happen. So your backup will be a first party supplemental needs trust, knowing that there's going to be other complications, especially if guardianship is involved. Okay, Jennifer, I hope I answered your question. I may not have given you the answer you wanted, but yeah. Okay, thank you, Jennifer. Okay.
Next
Third
slide.
party, yeah. Oh, I was gonna say, third party trusts are reviewed with a lot less scrutiny by Social Security. By the way, if you've got a supplemental needs trust or your loved one is on Medicaid or SSI or Social Security, and they're the beneficiary of a supplemental needs trust or any trust, Medicaid and Social Security are going to want to know about that. If they don't know about that, you really need to get legal counsel to help you provide that information to Social Security and Medicaid. Because these third-party trusts are reviewed with less scrutiny, meaning the requirements for these third-party trusts are not as strict as these first-party trusts that we're going to talk about. Because as we're going to find out, these first-party trusts, they will be funded with the Social Security beneficiary's own money. All right, let's go. Okay, I think the best way for me to explain how these first party supplemental needs trusts come about is to tell you a little case story. So I had a client whose ex-husband, it sounds like maybe a question that was just asked, named their son, their divorce, as a beneficiary on his life insurance policy. He worked at Shell, so he was able to keep that policy for a very long time. He had it even after retirement, and named the son in his individual capacity as the beneficiary. So then we had to do the following. Luckily, guardianship was not involved, and so we were able to not have to go to court. We had to create something that's called a first party trust because the asset was directed towards the person on benefits in his individual capacity. So then we had to have a trust with the following requirements. The person who established the trust, that's called the grantor, that has to be a parent, grandparent, guardian, or court order, or under the 2016 S&T Fairness Act, the beneficiary can actually be their own grantor, and that was a big positive change. The trustee can be any person or entity other than the beneficiary, and the beneficiary's own funds are used to fund the trust. And it says mostly because Social Security will allow for what we call initial seed funding with, like, if you go to Chase and they want $100 to open the account, that's okay. It's needed if Medicaid or SSI beneficiary receives assets in their own name. We see a lot of these first party trusts where child support gets directed to it. The distributions, meaning how money comes out, has to be for the sole benefit of that beneficiary or child. And the money that goes into this trust has to be placed before their 65th birthday. Texas is one of the states that says if you put money in a trust or a pool trust and they're after 65, then it becomes like a gift. And then at the death of the beneficiary, the remaining assets must go back to repay Medicaid in the amount that Medicaid paid out. So for example, if Medicaid paid $10,000 and there's $20,000 in, then the state or states will first get the $10,000, and then and then whatever is left over will go to whatever the trust document says. These first party trusts are reviewed with the most scrutiny. So let's say you have a first party trust, but you haven't done a payback period, or the payback period or the language is not clear. Social Security has a trust review team. They are supposed to send you a notice that the trust is invalid, and they're supposed to give you, I believe it's 90 days to go to court to fix it. So just because the trust has problems doesn't mean it's not fixable. This is kind of the nicer, gentler Social Security system than what we've seen in the past. So that's good, but it's better for us to not even have to delve into the world of first party supplemental needs trusts. There's no cap on how much you can put into these first party supplemental needs trusts. Most of you are familiar with the ABLE account. If you're not, watch one of CPG's fantastic videos on these ABLE accounts, and you can see kind of the toggle between ABLE accounts and first party supplemental needs trusts or special needs trusts. Okay, so documents needed for incapacity. We started out today by talking about death and beneficiary designations and wills. And I understand how that motivates us, especially as parents, to do planning. But we also have to think about incapacity of ourselves. As a parent, that is not what you want to think about. You want to think about, I'm going to die a long, long time from now, with my kids are going to be taken care of. But if we become incapacitated, we still need to take care of ourselves. It's like that saying, if you're on the airplane, you got to put the oxygen mask over yourself. So make sure you have documents for your own incapacity. The first one we're going to talk about is a financial power of attorney. Sometimes it's called a statutory power of attorney. Sometimes it's called a business power of attorney. You want to make sure that you have this, that it is, I like the document to be effective upon signing, or what we call effective immediately, and not springing. It makes it easier for the people you name in your document to make financial decisions. It makes it easier for them to use. One of the things I like to do too is send that financial power of attorney to the financial institutions for their pre-approval. So just because you have your spouse listed as a beneficiary on your retirement account, that doesn't mean they have management capabilities. And retirement accounts that are held by financial institutions, it seems like they're under extra scrutiny. So the best practice is to get a financial power of attorney, and then maybe even that financial institution's own power of attorney. It's really two powers of attorney for one account, but you want to do that to make it easier for your loved ones. Even if you're married, you still need a financial power of attorney. So this is a very important document. If you don't have it and you become ill or incapacitated and you cannot make financial decisions for yourself, even if you've been married for years and years, your spouse, your family will have to go to court in order to get guardianship for you. So it's very, very important. Michelle, I don't know if CPG has any, if y'all have any other things you want to say about that financial POA.
Yeah, it's just so important because I mean, we even do it. Well, I even recommend people do these things for their adult kids. I mean, don't only think about yourself and about
Right.
your special needs child, but what if my son went away to Chicago for college? What if he got hit by an L train and he's an adult, but he's still my
Mhm.
child, and there's nobody up there to be able to help him. So we set up financial and general POAs, and I made sure he put my phone number on his refrigerator for his roommates. You
Yes.
got to think about everybody in your life. And then I turned around, made him sign the documentation for me as well, and my husband. We've all
Right.
signed all the papers.
Right, right. And then you want to make sure that you send them to the financial institutions for their pre-approval as well.
Mhm.
Um, I know that Social Security, and I just learned this at a conference I went to. You probably already knew this, but Social Security, number one, doesn't accept financial power of attorney. We
Right.
all know that. Okay, number two, I just learned that Social Security will now allow you to appoint backups, almost like a
Mhm.
representative payee in advance. I
And
had a,
that's I'm sorry, that's really important because if something happens to you and you don't have a backup representative payee already on the account, those benefits are going to be suspended until they figure out where this money is
Mhm,
supposed to go.
mhm,
So it's way better to just have that set up ahead of time.
mhm, mhm. So we want to make sure we have that financial power of attorney for financial decisions. Medical power of attorney will not be effective until you cannot make a medical decision. Who should be financial power of attorney? Who should be medical power of attorney? I tell my families it's not a position of honor, it's a position of work. So you really have to put the people in your life that are going to do a good job. Don't think, oh, well, my two daughters don't get along, so I'm going to put them as co-agents on my financial power of attorney, and that's going to make them get along. No, no, no. It's not going to happen. They're going to fight. We're all going to wind up in court, and it's going to be very expensive, and things are not going to go well. If you've got somebody that's going through a bankruptcy or isn't great with money, they probably don't need to be on your financial power of attorney. And don't be afraid to hurt people's feelings if they don't get on the document. This is your money. This is your life. You've got to put the people on the document that are going to do the best job. My brother, who's also my firm's care manager, he is number one on my medical power of attorney because he really just has a great sense of advocacy for our clients and then for our family. My sister, who is the mother of my special needs nephew, she is my detail lady. And she's used to keeping that big notebook that all the moms and dads have that have special needs kids. So she's used to doing documentation. A HIPAA release. It's a document that how I drafted. It's a group of people that can make or that can communicate to healthcare physicians on your behalf. I make it effective immediately, and then it will usually, how I draft it is for 2 years after your date of death. So if you've got those two documents, you still need a directive to physicians. A directive to physicians sometimes is called a living will, and it's a set of instructions for a very specific situation, and that is you are considered terminal, which in the state of Texas means that a doctor says you have less than 6 months to live, even with life-sustaining treatment. In that document, it is like a set of instructions to your medical power of attorney on what you want to have in case of a terminal or an irreversible condition. So a DNR is different than a directive to physicians or a living will, because that has to do with somebody doing like CPR intervention. So I have a directive to physicians, but I do not have a DNR because I feel like I'm in still pretty good shape, and I'd like someone to at least try to do CPR. If you have a HIPAA release, make sure that whoever is on your financial power of attorney is also on your HIPAA release so that they can get health insurance information. And if you go through a healthcare campus, such as Methodist, MD Anderson, and they've got my chart, go ahead and load up your medical power of attorney HIPAA release direct to physicians up into your my chart portal, so that if you do go to the hospital or your loved one goes to the hospital and they say, do you have advanced directives? You can say with certainty, yes, and they are already on file. Okay, Michelle, anything that y'all want to add on that?
No, that sounds good. The one thing I was thinking about when you were talking about the directive to physicians, in my family, my mom got ALS, and so we had to watch her through that whole situation. So that's where I would say something like if I get that kind of degenerative disease, I don't want you to wait until my body just gives out, but maybe the point where I get this way or this happens, I'm gonna be like, that's plenty for me. We don't need to keep that going on. So it's really important to have that and those ideas in place. And in, all of this planning, think about what you want for yourself after your death as well.
Right. I'll go back one little thing. So that's the one slide. That's the appointment of designation of remains. Just a couple of
Uh-huh.
yeah. So we have an appointment of guardianship for yourself and child, where you can appoint somebody ahead of time to be a guardian if there's no power of attorney, or if the person can't sign a power of attorney. They still have to be vetted, as we're going to talk about here in just a second. And then appointment of healthcare agent for minor child. I have 2 minor children. And so I've got a list of people that can make healthcare decisions for them if I'm out. And then appointment of designation of remains, especially if all of these documents are important, especially if you're in a second marriage with a blended family with a special needs child. Because everybody needs to know who's going to do what when, and who's going to be able to handle the funeral. It's a gift that you give your family so that they are able to follow your instructions. And it, not that it will eliminate family disputes, but it can help reduce family disputes. Okay, thank you so much. Okay, so let's talk about guardianship, Michelle.
That's a big one.
Yeah, so guardianship is one of those things that it's going to be different for every single family. It's like a vacation. Like some people really like a beach vacation, and that's good for them. Some people don't like a beach vacation. So don't, just because your neighbor or your friend has a guardianship or doesn't have a guardianship, it's very individualized. So you can start the process right before their 18th birthday, file after their 18th birthday. Sometimes if the school is requiring a guardianship, sometimes the family and I will just sit down and talk about something that's called an educational power of attorney. So what I like to do is maybe 6 months before the person turns 18, have the family come and talk to me, and then we'll go over and see what our plan of action is going to be. Just because you don't get it at age 18 doesn't mean that you can't get it later. But once you have a guardianship, it's going to be very hard to remove. So it is a legal process. It's expensive. It requires another lawyer called an ad litem, that their job is to represent the legal interests of that person who's getting a guardianship. Because when you get a guardianship, you're taking away some of people's rights. So some of their rights may still be left there. So sometimes they'll still be able to vote, or they'll be able to contribute to making healthcare or housing decisions, but some right is going to be taken away from them. You also have to know that every year you're going to have to file an update with the court. And when the court establishes the guardianship, it's usually either a guardianship of the person, meaning there's no money or no estate, or a guardianship of the person and estate. And I'll tell you, my least favorite things to do are these annual accountings for my clients. Because it's like reporting. You have to keep your documentation if you've got money in your child's name. So for example, you left a life insurance policy to them. Maybe you have to report to the court about how you're using those life insurance proceeds. You have to be able to have receipt for every single penny.
Mm.
The court is going to have to approve financial decisions if you want to move the ward. And you're going to have to be able to show the court that there's no other least or less restrictive alternative, including a financial power of attorney, medical power of attorney, or HIPAA, or a supported decision making. That's actually the language in the statute, that there's no other support or service, there's no other least restrictive alternative. So that is a fairly high bar. And so
Yeah.
sometimes what we'll do is we'll get what we call a PCME, which is just a physician certificate of medical exam. And I'll have the family go 6 months before the person turns 18, just to see what their doctor that knows them the best thinks. And then we'll kind of test the water there. I think we had a question.
Yeah, just a quick one. If you get guardianship in one state and then move, do you have to start over or just transfer it, or what does that look like?
Yeah, Myrna, that's a good question. It's going to depend on the state that you're moving to. So number one, if you have the guardianship here in Texas, before you would move, I would advise contacting the guardianship coordinator where you establish the guardianship, to see what that court would want you to do. Sometimes they'll want you to go ahead and start the guardianship in another state and then transition. Each state will have their different transfer process. I just know that it can be very expensive to transition. So, and you want to have somebody that is familiar with that transition process from state to state. That's a great question. Okay.
Now, when it comes to guardianship, I mean, these are all kind of, you know, I'm not going to say everything on this list is negative, but why do people want guardianship? Why do people get it? And why is it helpful?
So I see a lot of people who like guardianship if they've got children that are nonverbal, and that child maybe on the autism spectrum is nonverbal, and then they like to be able to make decisions for their child. A lot of times, if you have a child like my nephew, who I don't know if he'll need guardianship or not. I'm just kidding. I mean, really, the jury's kind of out on him. But for people who are heavily involved in the medical system, like Texas Children's, like that, my chart locks out when you turn 18. So they want to be sure that they can talk to their child's medical providers. If the child may be at risk for bad actors, or that someone coming in to take money from them, they may want to get guardianship. And then also, yeah, so Tammy's talking about she wants guardianship because her daughter can't speak in it. Yes, I understand. that is wanting guardianship for that. Remember, every child's disability is going to be different, and so every child's need is going to be different. But that is a great question. Let's see, there was one. Just want to respond to Gina. If a parent gets guardianship, it's not the state, it's the county that has to be updated each year. So you have one form that would be for guardian of the person, where you talk about their physical needs, how often they go to the doctor, what their activities are. And then you will have another report on how much money you're spending on them. So Gina, if your child, if all they have is like a social security, they don't have any money in their name, the only entity you would be responsible for reporting would be to Social Security. But let's say that life insurance that we talked about, they will want to make sure that whatever you're spending on is only for that child, and that you're following the budget that you have presented to the court at the beginning of the guardianship. Yeah, so that's why it's the guardianship of the estate is something I would really want you to avoid. And you can use the Supplemental Needs Trust to avoid that, because any money that goes into the Supplemental Needs Trust, the court is not going to be, or will most likely not be, super interested in, unless there's some sort of report of financial misconduct. Let's see. Okay.
Yeah, I think that's about it.
Okay. So, Michelle, I know I've talked about updating beneficiary designations, but do you have any stories from the CPG desk about updating beneficiaries, or bad beneficiaries, or?
We have a lot of times where somebody, like a spouse, is accidentally left on who is an
Oh, that's a
ex
nightmare.
now. And the person passes away without checking these things out, and they never
Yeah,
fixed it.
yeah.
And it can just be very troublesome. But like I said, we talk to everybody about this and we go through it with them. So we don't really have that many horror stories, because we help people fix it
Yeah.
up.
So I have kind of two parts to my office. I have like the pre-planners, and then I have like things that like kind of like emergency planning, and both are okay. Both are okay. We get it, because sometimes for families, it's not even their own assets. It's like a grandparent. Um, it's like a family member that left something to their child unexpectedly. That's where I usually see it.
Yeah.
Most of the time, it's not a mistake that the parents make. At least in my practice, other attorneys may have a different experience. But it's so important that not only do you update your beneficiary designations, but you look at grandparents, people that you love, people that may leave something to your child. You may want to have a conversation with them. I love Excel spreadsheets. They make me feel warm inside. So I have a list of, I have an Excel spreadsheet that I provide to my clients where they list all of their assets. We have a column that says, okay, if I'm incapacitated, what legal document controls? And then we have another column that says, if I die, where does the asset go at my death? And then we have another column that says, yes, if it's an IRA, that the financial institution has approved the power of attorney. So we talked about, if your child receives assets outright, it can cause a loss of eligibility for Medicaid. A lot of these Medicaid programs are hard fought for. So you may have been on that interest list for HCS for 15 years. We don't want to mess up. But if we do, we can use the first party trust and an ABLE account. Carefully review the beneficiary designations with your financial advisor, and then make sure you get written confirmation back from the financial institution that beneficiary designation has been updated. And then, what you really should do with all that information is share it with the person that's your financial power of attorney, and or share it with your executor. That's the person that handles your estate when you die, and or your trustee. So we want to make sure that the people that we've named in these documents have the information that they need to be successful. We want to set them up for success, not for difficulty or failure. So if you don't want your agent, your financial power of attorney, maybe who's your sister or cousin, to have access to this information, at least tell them, okay, this is where it's located. It's in the red folder or it's
Mhm.
in this is how you access it on my computer. Otherwise, it can be very hard for them to be able to do the things that you've asked them to do. I just don't think that's fair, but it happens all the time. Mm.
Or at least, at the very least, here's my financial advisor's contact information.
Mhm.
And, they know my stuff.
Mhm.
And here's my attorney. She
Mhm.
knows the stuff.
Mhm.
Here's my support team.
Mhm.
And,
Mhm.
they know.
Mhm. Mhm. Okay, so we talked about who's the trustee. That's the person that's going to be in charge of the money during the beneficiary or the person with a disability's lifetime. And I think they have to have the three T's: time, talent, and trustworthy. So what about a sibling serving as trustee? I mean, they're close by, they get it, they understand, but then it can make that relationship strained. Because you want your sibling, I mean, to be the siblings.
Mhm.
I always tell my boys, brothers love each other. That's, I told them I may not always be here, your dad may not always be here, but y'all are gonna have each other. Anytime we get money in that equation, it can be stressful. What about a bank? What about a corporate trustee? Like the guardianship conversation, it's all gonna be individual on each family. And how to divide the estate, what's fair. Maybe you've got a second marriage and you each have kids from a previous relationship or marriage. Really, what the best practice to do is to kind of just start big and figure out what's the percentages, and then we kind of whittle it down to which assets are going to fund those percentages. Michelle, do you want to talk just a second about the letter of intent, since y'all have got a great YouTube video on that?
Yes, absolutely. So the letter of intent is kind of like a love letter for your family. And you're going to write down, basically everything that a person needs to know if they're going to be the ones to come in and take over for you. Doctors' contact information. Who is that support team that I mentioned? What are your child's diagnoses and medications and routines? But in the letter of intent, you can also include the fun stuff, like what do they love? What do they really dislike? If they're having a meltdown, what can you do to fix it? Or what's going to cause a meltdown if you do those things? What family traditions do you have that you
Yes.
want continued?
Mm-hmm.
And spiritual and religious
Mm-hmm.
guidance that you want for your child.
Mm-hmm.
Those kinds of things go in the letter of intent.
Mm-hmm.
And I always advise people because in my previous life, I was an English teacher. So I always advise people to just, start with the facts
Mm-hmm.
and then that will flow into those fun things, those
Mm-hmm.
fun extras, and get your whole family involved because maybe, your loved one with the disability they have things that they want to let people know, if they're verbal. If they're nonverbal or, even if they are, maybe their siblings have some insights that you haven't thought about. So get everyone involved and let this be a living document, something that you're going to change and update as the years go by, because your family and your loved one is going to grow and evolve.
Mm-hmm. And then that way we can make the trust document shorter. And then
Mhm.
it's just like a letter of instruction to the trustee. And especially if you have a corporate fiduciary or a bank or financial institution, they welcome those types of instructions.
Right.
Um, be sure that the people you've appointed know that they're appointed. I have a lot of times people come in and say, I had no idea I was the trustee or the guardian or the executor. I don't know, like I said, if I can give you one thing to take away, check those beneficiary designations. When do you need to update your documents? I'd say once a year. I'm not saying go to a lawyer once a year, but I'm saying set a uh Labor Day weekend is my new day to do it. So a couple of weeks from now, I'm going to be checking, not that I have that many accounts, but the 2 or 3 accounts that I have, I'm going to go through and I'm going to make sure that everything's in good shape. If you have a death or divorce, make sure that the people that you've appointed are still able and willing to serve. Maybe especially as we get older, our aging parents may not be great trustees or guardians for our kiddos. So
And when you're doing that once a year, checking your designations, your beneficiaries and that kind of stuff, it is also a great time to take a look at your accounts, your assets. Are they growing? Are they just sitting there? Are you losing money?
Mhm.
If you want an in-depth look, we would analyze all that for you, but don't just set your money out there and let it go and don't ever look at it.
Yeah, it's like a garden. We have
Yeah.
to nurture, we have to check, we have to monitor. Um, and I found that this process is so can be so scary and arduous. It doesn't have to be. Michelle and I will help you take little baby steps and
Yes,
walk
baby steps.
together. It's not going to happen overnight, but you do a little bit, and then eventually it will be done, and then you'll have a product and a plan that will be a lot easier to review on an annual basis. I think we had another question in the last minute or
Yeah,
two.
Christina, this is one that we get a lot, and I would love to hear your perspective.
Okay.
What if there truly is nobody? There's
Yeah.
no family members, there's no help out there. What can people do? If
It's really tough, and it's as far as the trustee, a lot of my families are not necessarily the multi-million dollar people. They're working families. And
yeah,
so we may have to look at, if we don't have a family member, we may have to look at something that's called a pooled trust. And the Arc of Texas Master Pool Trust has no minimums because that's the problem with getting a corporate fiduciary. That may or
hmm.
may not be a good fit. People have different feelings about the pool trust. Um, and so we don't typically appoint the county. It's not a county, but it's a nonprofit. There are some other corporate fiduciaries that have lower amounts that I can work with the clients. But maybe that's a call for families to get life insurance so that you can have the benchmarks for these corporate fiduciaries. And there
Yeah.
are corporate fiduciaries that are willing to continue to work with your financial advisors, that we can talk you through. But it is a real problem. And Gina, the other problem, and I don't know if this is in your family, is who is going to be guardian of the person. Sometimes we just absolutely have nobody. And
Mhm.
there are very limited there are some professional guardians, um, but I'm not
Well,
that.
many times that professional guardian is in the form of a residential community, but those can be so expensive
Mhm,
that
mhm.
that's not right for everybody either.
No, no.
Um,
I am starting to see some smaller businesses that are wanting to come and be executor or financial power of attorney, and or trustee. But Gina, it's tough. I don't necessarily know if I have a silver bullet answer for that question.
well, I have had this slide up because I want to encourage everybody. We've already shown Christina's contact info, but this is how you can sign up for a free consultation with Consolidated Planning Group. What we do during this consultation, first of all, it's virtual, it's on Zoom, just like this meeting. Um, we go through any questions that you have. We want to learn about your family. Um, we have a short questionnaire that you fill out beforehand, and then we answer any questions you have about the planning process or specific questions about your situation. Maybe if we didn't get to something you wanted to ask today, we could answer that question. Then we would talk to you a little bit about how we work, what our fees look like, and that sort of thing. And you decide from there if you would like to go forward and work with us. So I hope you'll all sign up for this free consultation. You can use the QR code. You can call or email the office, or you can call or email me directly. And there's about a 50-50 chance, maybe 60-40 chance that your initial consultation would be with me. So go ahead and sign up. I promise I'm friendly. I don't bite. You can also follow our social media tabs there. Um, and again, so Christina, do you also offer a free consultation or an appointment
No,
for more information?
Yeah, we don't do a free consultation because we very carefully vet our clients at the front end. Our consultation is usually an hour and a half. I do charge $5.95, but we deduct that from the flat fee that we charge to do the work. So you come, you meet with me, and you'll come away with a PowerPoint presentation and a plan that is tailored for your family. And then you can decide whether or not you'd like to work with us or not.
Perfect. Thank you so much, Christina, for all of the fantastic information, and to Lourdes for being here and helping host this webinar. And most of all, to all of the participants who have been here with us today. Please reach out to any of the three of us if you have any questions. We are here to help. And we hope that we get to hear from you. Everybody, enjoy the rest of your summer. I know people are going back to school right now, and just reach out to us with any further questions. I think this is the last thing. We're out of time, but Myrna wants to know, if you don't have any assets, do you still need this? Um, if you don't have any
Yeah,
assets, I think you need us, all three of us, even more,
yes, yeah, yes.
right? Yeah, that's what I would have to say about that. All right, everybody, thank you so much for being here with us today. I hope we hear from you soon. Bye-bye.